Welcome to this masterclass explainer on crafting your MOA, or Memorandum of Association. If you're an early-stage founder or a company director, listen up, because this document is literally the foundational charter of your entire company. Think of it as your ultimate corporate shield. Today, we're locking down exactly how to draft it step by step so you can protect yourself from personal liability and, just as importantly, ensure you are completely investor ready.
Here is our chronological workflow for today's masterclass. The corporate shield, naming and location, drafting the object clause, liability, capital and formats, signatures and subscribers, and finally, updating for investor diligence. Let's get right into it. Section 1, the ultimate corporate shield. So, under the Companies Act of 2013, you literally cannot form a company without an MOA. It defines the strict scope of your operations and sets the absolute boundaries you cannot cross. To put this in perspective, check out this landmark 1875 ruling. It's kind of wild that a railway dispute from way back then practically dictates the boundaries of your modern startup today. Lord Cairn noted that the MOA contains both what is affirmative and what is negative. I want you to visualize your MOA as a giant fence. It affirmatively states your company's powers, what you can legally do inside the fence, and it negatively restricts you from stepping outside of it. But what happens if you, as a director, decide to hop over that fence? Well, you commit what is legally known as an ultra-vires act. This just means you've acted beyond the legal powers granted by the MOA. And let me tell you, for a director, the legal consequences here are incredibly high stakes. Here is the statutory warning you need to pay attention to. Section 245 of the Act actually allows for a class action lawsuit to be brought before the National Company Law Tribunal, or NCLT, for ultra-vires acts. And guess who brings the suit? Your own depositors or members. No way do you want to deal with that. To mitigate the risk of a terrifying class action lawsuit against you personally, your MOA has got to be drafted flawlessly under Section 4 of the Companies Act. Section 2, Naming and Location Rules. The first two clauses of Section 4 are your name and registered office. Let's break down the regulatory red flags you've got to avoid here. Now, you reserve your company name via the RUN facility, that's Reserve Unique Name, or the SPISC Plus form. But you really have to watch out for these strict Rule 8 restrictions. A massive mistake founders make is thinking they can skirt naming rules with just slight tweaks. You can't just add an S to an existing name, like changing pedal provision to pedal provisions. You can't just add punctuation, like go.digit. And you definitely can't just change the tense. Investors and the Register of Companies, the ROC, will immediately reject those attempts. You have to keep it truly unique, and don't forget those mandatory limited or private limited suffixes. Once you've got the names sorted, you need your registered office clause. This is a simple statement indicating the state where your company is domiciled. It's absolutely crucial because it dictates your ROC jurisdiction, meaning which specific registrar is actually monitoring you. You have to inform the ROC of the exact location within 30 days of incorporation. This is the official home where your common seal and statutory books are legally kept. Moving on to Section 3, Drafting the Object Clause. Now we reach the absolute soul of the company and your primary defense mechanism against those massive lawsuits we just talked about, the Object Clause under Section 4C. To see how a strategic object clause actively protects directors, let's look at a practical example for a building materials company. Notice how incredibly broad this text is. It lists everything from sand and timber to elevators and chemical substances. A fundamental best practice for founders is to draft this clause to include all probable businesses you might carry out. You want your corporate fence to be as wide as possible. That way, if your startup pivots slightly down the line, you aren't suddenly committing an ultra-vires act and exposing yourself to personal liability. All right, Section 4, Liability, Capital, and Formats. Next up on our masterclass checklist, we need to structure exactly how your investors' money and your own legal obligations are officially handled. The liability clause is what lets founders and investors actually sleep at night because it caps your financial exposure. If you're limited by shares, your liability is strictly limited to the shares you own if the company goes insolvent. If you're limited by guarantee, it's limited to a specific amount you explicitly agreed to contribute during winding up. Hand in hand with this is your capital clause, which sets your authorized capital ceiling and your minimum paid-up capital. Keep in mind that minimum is 1 lakh rupees for private companies and 5 lakhs for public companies. So, how do you actually format all these clauses? You can't just open a blank document and start typing. Under Schedule I of the Companies Act, your MOA must exactly match one of 5 structured formats, tables A through E.
Your choice here is directly dictated by the liability and capital structure you just decided on. For example, if you're limited by shares, you simply use Table A. It's simple, standardized, and legally robust. Section 5. Signatures and subscribers. Okay, you've drafted the clauses and you've chosen your table format. To bring this corporate charter to life, we move to the execution phase, the association or subscription clause. This represents a strict chronological workflow. To form the association, subscribers must agree to take a minimum of 1 share each. You need at least 7 subscribers for a public company and 2 for a private one. They must sign in front of at least 1 witness who attests the signatures. And do you know the most common filing mistake founders make here? Having subscribers witness each other's signatures? You absolutely cannot do that. The witness must be an independent third party. Make sure you attach all written addresses, occupations, and subscriber photos, and then boom, your MOA is finally fit for registration. Finally, Section 6, Updating for Investor Diligence. Fast forward a bit. As your startup successfully grows, your business activities will inevitably evolve. The fence you built on day 1 might start feeling a little too tight. This is exactly where early-stage founders often get tripped up during venture capital funding rounds or M&A. VCs will heavily audit your MOA during their legal due diligence. They're going to ask pointed questions like, are current revenues generated from legally approved objects? And does the current MOA allow for our planned exit strategy? If they see your business is operating outside its stated objects, that signals massive unmitigated legal risk. An outdated MOA is a giant red flag that can literally kill a funding round simply because investors do not want to buy into an ultra-vires lawsuit. To proactively protect yourself and stay investor-ready, you must formally alter your MOA as you grow. It's a specific 3-step process. Step 1, pass a special resolution with your members. Step 2, obtain necessary government approvals if your specific alteration requires it. And Step 3, file the mandatory Section 13 documents with the ROC so they can register it and issue a fresh certificate of incorporation. Pro tip, always do this before you start a new line of business, never after. We've covered a ton of ground today. The 6 steps we just walked through serve as your ultimate structured compliance checklist to verify regulatory compliance before submission. But I want to leave you with this final critical question. Think about your day-to-day operations right now. Is your company currently operating outside the fence of its object clause? I urge you, as a director or founder, to pull up your MOA today and review it. Are you totally shielded, or are your daily operations putting you at personal risk of an ultra-vires lawsuit? Protect your shield so your shields can protect you. Thanks for joining me on this explainer, and I'll catch you next time.